Ladies and gentlemen of the jury, I expect my closing argument to be about an hour and 15 minutes. I get to talk once, the prosecutor gets to talk twice. I will necessarily be a little bit longer than he was. The closing argument will consist of 4 parts. First, I will discuss 2 jury instructions that are particularly important to your deliberations. Secondly, I will discuss the crimes the prosecutors have alleged and discuss the evidence or lack of evidence regarding those crimes. Third, I will respond to a few things that the prosecutor said this morning. And fourth, I will conclude with a very short story and a quote that I think is applicable to your jury service in this case. To begin the first part, the first jury instruction I will discuss is instruction number 4, and that is the instruction on the presumption of innocence. That instruction means that when you begin your deliberations, you must all start with the mindset that Stanley Donahue is not guilty of every single crime that the prosecutors have alleged. We all heard in jury selection how the prosecutors thought the presumption of innocence was important, but as I referenced in my opening statement, the first time they had a chance to talk with you, they committed themselves to asking for guilty verdicts before any of us knew what the evidence was going to turn out to be in this case. That was a disregard and a throwaway of the presumption of innocence. And if that presumption in jury instruction number 4 is to have any meaning in this case, you will be the ones to give it that meaning, and you can do so, as the instruction requires, by beginning your deliberations with the mindset that Stanley Donahue is not guilty of each alleged crime. And you cannot change your mindset on that presumption unless you conclude that the prosecutors have proven any given crime beyond a reasonable doubt. And beyond a reasonable doubt is the second instruction I will mention in this first part of my argument, and that is instruction number 6. And it means you must find Stanley Donahue not guilty of every single crime if the prosecutors have not proven any given crime beyond a reasonable doubt. You might all have at least a slightly different idea of what a reasonable doubt means after reading that instruction. So in an attempt to have you thinking about reasonable doubt the same way during your deliberations, I will suggest here a couple of ways that you should think about reasonable doubt in your jury deliberations. The first way is, if you are a reasonable person and you have any doubts about Mr. Donahue's guilt, those doubts must be reasonable, and those doubts require a not guilty verdict. A reasonable person cannot have a doubt that is unreasonable. So if you're reasonable and you have any doubts, those are reasonable. They require not guilty verdicts. The second way will take a little bit more explaining, and I referenced this in my opening statement. Proof beyond a reasonable doubt means that the only possible explanation from all of the evidence and the lack of evidence in this case is, 1, that Mr. Donahue was the person in the cases, and 2, that he committed every checklist item for every single crime that the prosecutors have alleged. Proof beyond a reasonable doubt means that that would have to be the only explanation, because you cannot think beyond a reasonable doubt a person is guilty if you can also think at the same time it's reasonably possible the person might be not guilty. So as long as you can hold at least one reasonably possible explanation from the evidence and lack of evidence, is that someone other than Stanley Donahue was the person in the cases, you have reasonable doubts that would require a not guilty verdict. Or as long as you could hold at least one reasonably possible explanation from the evidence and lack of evidence that the person in the cases might not have committed any given checklist item for any given crime, your verdict must be not guilty regardless of the identity issue. So proof beyond a reasonable doubt, again, does not mean that one reasonably possible explanation from all of the evidence and lack of evidence is that it was Stanley Donahue and he committed every single crime alleged. Rather, proof beyond a reasonable doubt means that would be the only reasonably possible explanation. And for the prosecutors to prove that is the only reasonably possible explanation, they have to rule out the possibility that someone other than Stanley Donahue might have been the person in the cases. And they must rule out the possibility that the person in the cases might not have committed every single checklist item for any given crime. So that would mean that the prosecutors have to rule out the possibility that Michael Goldmeyer, born in 1997, or any other person other than Stanley Donahue, might have been the person in the cases. If you conclude the prosecutors have not ruled out the possibility that at least one other person other than Stanley Donahue might have been the person in the cases, there is reasonable doubt on the identity issue, which would require not guilty verdicts. Or, for example, on the attempted murder charge, if the prosecutors do not rule out the possibility that the person in the cases might not have intended to kill Deputy Halverson, then there would be reasonable doubt on the attempted murder charge, regardless of the identity issue. So the reasonable doubt calculation you must make during your deliberations is not a metaphorical tug of war between thinking either it was Stanley Donahue in the cases or it was not Stanley Donahue in the cases. You can reasonably think it's possible that it was Stanley Donahue in the cases, while also thinking it's reasonably possible it was not Stanley Donahue in the cases. And if you can do that, there's reasonable doubt on the identity issue that would require a not guilty verdict. My final comments on reasonable doubt before moving on to the second part of my argument harken back to the example I gave in jury instruction about the bottle of Tylenol during that national recall. Everyone agreed that they would have a reasonable doubt about the safety of the pills in that Tylenol bottle, even though the statistical possibility of a pill in the bottle actually being poisonous was very small. And that belief was reasonable because it was reasonable to not take the risk of consuming a poison pill. That would be very harmful, despite however much it would cost to throw out the pill bottle. Therefore, whether you have a reasonable doubt does not depend on the size of the doubt you have. It only depends on whether the doubt is reasonable. So you could have the tiniest doubt about whether Mr. Donahue is guilty, but as long as it remains a reasonable one, it requires a not guilty verdict. Analogizing to the Tylenol example, for possibly the last time, tiny doubts are reasonable in criminal cases because the risk of being wrong is large, branding a person a criminal on potentially proof less than a reasonable doubt. Just like the risk of taking a poison pill was too large to bear. And there is only one person who has the potential to be branded a criminal with your verdict, and that person is Stanley Donahue. So tiny doubts are definitely reasonable doubts when ignoring them could result in the branding of a person as a criminal on something less than proof beyond a reasonable doubt. So if you have a tiny thought in your mind that Michael Goldmeyer or anyone else could have been in the Caseys, that's a reasonable doubt. If you have a tiny doubt in your mind that the perpetrator may not have intended to kill Deputy Halverson, that's reasonable doubt on the attempted murder charge. So a final question I will pose before moving to the second part of my argument is this. If the prosecutor's case were a bottle of Tylenol during that recall, would you feel safe taking a pill from it? If the answer is no, you would not feel safe. You have reasonable doubts that require a not guilty verdict. So with those thoughts about reasonable doubt in mind, I will move to the second part of my argument. To begin this part of the argument, I will pose to you a reasonably possible explanation that you can reasonably infer from the evidence and lack of evidence in this case that allows you to conclude Stanley Donahue might not have been the person in the Caseys. This will sound like a lot. Most of them will be quick. I will then discuss 18 reasons based on the evidence and lack of evidence that allow you to conclude the scenario I'm about to pose is a reasonably possible explanation from the evidence and the lack of evidence. And please keep in mind in your deliberations, you do not have to limit yourself to the consideration of the scenario I'm about to pose. The prosecutors have to rule out the possibility of the scenario I'm about to pose. They have to rule out the possibility of any variations on that scenario you might think of yourself. And they have to rule out every other single possibility other than Stanley Donahue before you can conclude they have proven their case beyond a reasonable doubt. So I will only mention this one reasonably possible scenario, but again, please do not limit yourself to consideration of this one. And Mr. McAreevy may have a few slides that will appear periodically on the screens in front of you as we go along. So here is the reasonably possible explanation from the evidence and lack of evidence in this case that would allow you to conclude Stanley Donahue might not have been the person in the Caseys. And it is this. Stanley Donahue and Michael Goldmeyer, the individual born in 1997, not the older one, the younger one is who I will be referring to. They are brothers and they live in Chicago. And as you've heard, they have a sister who lives in Ryan, Iowa. Under this reasonably possible scenario, they are in Ryan visiting their sister. Stanley does not have much money and he has no bank, so he takes his money with him whenever he travels anywhere. They plan to leave for Chicago on June 20th.
Your Honor, objection to the approach.
Any approach? Ladies and gentlemen, prepare for that noise. Ladies and gentlemen, there has been an objection. The statement that Mr. Donahue and Mr. Goldmeyer might have been planning to leave for Chicago, you should disregard. You should not disregard anything else you've heard, just that single statement. Go ahead, Mr. Steve.
In the reasonably possible scenario I am posing, we will continue. The van that's registered to Stanley is at the Casey's on June 20th around 10:15 or 10:30 in the evening, whatever time it was. No one ever looked in the van when it came to an investigation, so it cannot be ruled out that it's possible there were multiple people in that van. The evidence showed that only one person ever left the van at the Casey's. And when that one person left the van from the Casey's, he left from the Casey's twice. And on the video, it was obvious it was the same person leaving the van both times. And at some point, that person comes back to the van, and the van drives away. But not before Deputy Halverson came in, ran past the van and ran in the store, and acted heroically as he did. But, again, there was no look in the van, so the possibility that there was a second person in the van cannot be ruled out. So the van drives away from Casey's, and it eventually crashes on the Buffalo Creek Bridge, which is represented on the red tab in Defendant's Exhibit K. And both airbags deploy. The driver runs from the vehicle. Deputy Heath Omar chases the driver and does not stop to look in the van. Not faulting him for that, it's simply a fact as to what happened. At that point, as Deputy Matt Doltman's testimony has showed, he could not rule out the possibility that the passenger side airbag in the van will only deploy if there is a person sitting in that passenger seat. He's told that to you twice. Once when he was originally called to testify in this case. We asked him about it. He acknowledged that was all true. Then after that, he went and looked into the van more and came back and testified a second time and confirmed to you that he could not rule out the possibility that the airbag would only deploy if there was a passenger sitting in that front passenger seat. So at the time Deputy Heath Omar runs past the van, the possibility that a person was in the passenger seat cannot be ruled out. So there is a reasonable doubt as to whether there were at least two people in the van. And because Stanley Donahue was never found shortly after that van chase, it was 14 or 15 hours later, you can reasonably conclude that the person who fled the van was not Stanley Donahue. So from the evidence and lack of evidence, that raises a question. If Stanley Donahue was in the passenger seat of the van, what happened to him? As Deputy Steinis' testimony established, he said there was about a 10-minute break between the time Heath Omar called out that he had stopped in the spot where he last saw the driver and the time that Deputy Steinis arrived at Deputy Omar's location. So we will get to this later in the argument, but there's a 10-minute window there where a person could have left that van without being detected by police or anyone else. There was also a pair of white Nike shoes found in the back of the van. As it appears Mr. McAreevy is pulling up. And the pair of shoes in the van raises the reasonable inference that whoever was in the van left without putting those shoes on. And then we get to the police chase, or manhunt, or search, whatever you choose to consider it as. Manhunt seems to be the prosecutor's favorite term for some reason. testimony is undisputed that whoever the driver of the van was ran from the red tab on Exhibit K to the green tab on Exhibit K, and that green tab is where Deputy Omar last saw the driver. The testimony is undisputed that the dog track that Deputy Steinis and Bingo and Heath Omar conducted led to the purple tab on Exhibit K. And that ended, I forget the exact time, but maybe around 11 p.m. or so on June 20th of 2021. But of course, the dog track that led to this purple tab on Aldrich Road never led to Stanley Donahue, so you can reasonably infer from the evidence that Stanley Donahue was not the person that the dog, the expert handler, Deputy Steinis, and Deputy Heath Omar were tracking. And then around 11:30, there is the sighting, marked as the blue tab on Exhibit K, of a person crossing Highway 13 southbound near the intersection of Monticello Road. And a reasonable inference from the evidence that the prosecutors cannot rule out as a possibility is that the person who ended the track on Aldrich Road by the purple tab may have briefly ran north on the gravel road of Aldrich Road, because that's a reasonable explanation as to why the dog track would have ended. Deputy Steinis said it's hard for the dog to track on gravel. And then whoever that person was, after going north for a while, started running east, because he knew the police were coming from behind him, which was to the west, so you can reasonably infer that person was going to run anywhere but west. And as the person is running east from that purple tab on Aldrich Road, or a spot slightly north of it, that person is gradually drifting to the south. Inadvertently, possibly, but maybe by design. And as that person drifts to the south, he is spotted crossing the intersection of Highway 13 and Monticello Road, marked by the blue tab. That sighting came in around 11:30 p.m. And then somewhere in the area of the pink tab on Exhibit K, at 2 a.m. on June 21st, there was the report of cows making a lot of noise, which was suspicious as possibly being caused by the driver of the van. So, you can reasonably conclude that it might be possible that the driver of the van that was tracked to the purple tab on Aldrich Road eventually continued going east, went south across Monticello Road and Highway 13, kept going south through the cows on 1297 Upper Boulder Road, and slipped through the police perimeter and back to wherever he came from. But then what about the fact of Stanley Donahue being found on Aldrich Road by the purple tab and the post-it note, which indicates where he was arrested? And that gets back to the reasonable possibility of a person being in the passenger seat of the van and leaving a pair of white shoes in the van. It is a reasonable inference from the evidence and lack of evidence in this case that the person in the passenger seat fled the van without his shoes on because of fear and concern and apprehension as to what was happening. Didn't know where to run, but knew he had to run somewhere, and ends up running a similar route as the driver of the van took. That person doesn't know what to do, knows the police are chasing him, or at least the driver of the van, not knowing any better, not having any better ideas. He ends up in a field in the middle of the night and lays low to hopefully avoid detection, because certainly by the next day, whatever was going on with the person in the KCs is going to be over with and resolved, and at that point, he can come out of the field and find his way home. And that is a reasonable inference from the evidence and lack of evidence in this case as to how Stanley Donahue was arrested on Aldrich Road near the purple tab and the Post-it note displayed on Exhibit K. I will get into the rest of the details of that reasonably possible scenario I posed in the 18 points I will mention as to why you can reasonably infer that is a possible explanation of the evidence and lack of evidence that the prosecutors cannot rule out. The first part is the identification issue, and this will be the longest part of the evidence I will discuss. And in doing so, I will refer again to jury instruction number 11, or refer for the first time to that. And that is a jury instruction on factors that you consider regarding the unreliability of eyewitness identifications. You do not have to limit yourself to considerations of those items in jury instruction 11. You can also consider all of the testimony you heard from Dr. Lambert. Regarding the eyewitness identifications, there is reasonable doubt about the eyewitness identifications made in this case because you can reasonably conclude that it's possible that the eyewitnesses might have been mistaken. I will first discuss the one out-of-court identification made in this case, and that belongs to Jacob Christensen. Then I will move on to the in-court identifications. On a related note regarding that out-of-court identification that Jacob Christensen purportedly made, the lead detective in this case, Sergeant Abel, did not know about that until approximately 1 year after it supposedly happened. A question you can reasonably think from that undisputed evidence is, if the lead detective in the case took 1 year to discover a piece of evidence purportedly as important as an identification, what other evidence might he and the rest of the investigation have missed? And what other evidence is still out there that they have not found? Moving to Jacob Christensen's identification. Lead Detective Sergeant Abel and Lieutenant Buter both said, regarding that out-of-court identification, that they could not rule out the possibility that when Jacob Christensen looked at a picture on June 21st and identified the person in the picture as a perpetrator, that Jacob Christensen was looking at a picture of a person other than Stanley Donahue. If they cannot rule out the possibility that Jacob Christensen looked at a picture other than Stanley Donahue and identified that person as the perpetrator, they cannot rule out the possibility that less than 24 hours after the incident, when the incident was freshest in Jacob Christensen's mind, that he identified a person other than Stanley Donahue as the perpetrator. The inability of the prosecutors to rule out that possibility by itself creates reasonable doubt on the identity issue.
Objection, Your Honor. Can you approach again?
You may. Mr. Steeple, you may proceed.
Regarding the out-of-court identification from Jacob Christensen, even if the picture that he was shown was of Stanley Donahue, for all of the reasons Dr. Lampinen gave in his testimony, that one-man photo show-up is inherently unreliable, and therefore its inherent unreliability allows you to reasonably conclude that the identification may have been mistaken. When Jacob Christensen was asked about that identification under questions from the prosecutors, he said that he identified the person in the picture as a perpetrator, and that the officers did not say anything to him when it came to whether the person in the picture had just been caught or arrested or anything similar to that. Also under questioning from the prosecutor, he said that after the fact, the officer did not tell him anything about whether he had made a correct identification of the person that had been arrested. Under questioning from us, he said that the officer walked up with a picture who had just been caught and said something to the effect of, "This is who we just caught. Is this the person you saw in the Casey's?" Jacob Christensen said something to the effect that it was, and then according to Jacob Christensen's testimony, the officer said something to the effect of, "Good, we just wanted to make sure." So the combination of the officer's suggestion to Mr. Christensen that the person in the picture had just been arrested, only showing him one picture, makes that identification unreliable, or at least reasonably possible that it's unreliable. Additionally, telling Jacob Christensen afterward that he did make a correct identification makes it reasonably possible that Jacob Christensen's in-court identification was based off his memory of the picture rather than his memory of the incident itself. So there is reasonable doubt surrounding the one and only out-of-court identification procedure that the police and prosecutors ever bothered to conduct in this case. Moving now to the in-court identifications, to have a reasonable doubt about those in-court identifications, you only have to think that it is reasonably possible that the identifications might have been mistaken. I will not go through it blow by blow, but on this part, you should consider Dr. Lampinen's expert testimony that he gave on Friday. I will summarize it briefly here. Head coverings such as hoods make identifications unreliable because the brain does not remember faces by one or two facial characteristics like big nose, big lips, or big forehead. Rather, the brain remembers faces as a whole, including the ears and the tops and the sides of heads. High-stress situations, such as seeing a weapon, being scared, or thinking how to address the threat a perpetrator is posing to you, result in unreliable identifications because during those times, the brain is focusing on how to address the threat rather than focusing on facial characteristics. Cross-race identifications are unreliable when the eyewitnesses don't have much experience around people of the same race as the person they are viewing. Short exposure times create unreliability. And in all of the studies Dr. Lampinen discussed, the lighting was good. So lighting being good by itself does not create reliability. Additionally, all the studies he discussed, except the one on the 2-second exposure time, had extensive exposure times. The one with the Army recruits, if you recall, I think had an exposure time around 30 minutes, which is much more than anything that you have in this case. Finally, before moving on to the identifications, being exposed to pictures of the suspect that label him as a suspect prior to any identification attempts make it more likely that the person will identify the person in the picture based on the memory they have of the picture rather than the incident itself. So, Mr. Christensen, the perpetrator, in his own words, had a hood on the entire time, and regarding the facial features of the perpetrator, the hood darkened everything up and blocked most of them out. So the good lighting is not a factor in increasing the reliability for Mr. Christensen, since despite the good lighting, the hood darkened up the perpetrator's face. The only physical description he could give was that the perpetrator had big lips, bigger lips than regular-sized people would have lips. His experience around black individuals was limited to one person that he saw at Casey's as a customer on a regular basis. Only 2 or 3 black classmates growing up during school, and had recently spent a year in Wisconsin where he did not see many black people. And he had seen the picture of Stanley Donahue in news articles and social media posts and otherwise 7 to 10 times prior to his in-court identification attempt. The combination of those factors allows you to reasonably conclude his in-court identification may have been mistaken and based off his memory of pictures. Madeline Stepanek, as State's Exhibit 3 shows, a Casey's video, from about 11:07 in that exhibit to about 11:36 was the only time she saw the perpetrator's face. It was the scariest experience of her life. The perpetrator had a hood on the entire time, limited experience around black individuals, and the only physical description was a bigger nose and mouth than what she normally sees. Perhaps most importantly for her identification, she said she had seen a picture of Stanley Donahue 20 to 50 times that labeled him as the suspect prior to her in-court identification attempt. All of that allows you to conclude that it's reasonably possible her in-court identification may have been mistaken and may have been based on her memory of the pictures rather than the incident itself. Deputy Heath Omar, the only description he could give was a black male with a big forehead. He could not say what color the perpetrator's eyes were. He could not say whether the perpetrator was wearing a hood. Plus, he saw the driver, by his own admission, for approximately 2 seconds in the dark from another vehicle while in a high-stress situation and driving at a decent rate of speed. And he also saw a picture of Stanley in an email that labeled Stanley as the suspect. The presence of all of those factors that create unreliability allows you to reasonably conclude that his in-court identification might have been mistaken, so there is reasonable doubt surrounding that identification. Deputy William Halverson, he gave a description of a black male, nothing else. Prior to the shooting, he was in the perpetrator's presence for only 3 seconds. During that 3 seconds, he looked away from the perpetrator to set his flashlight down. Mr. McAreevy might find a screenshot of that from the Casey's video that's admitted as an exhibit. He was thinking in his mind whether he could see anyone else in the store, and he was thinking how to address the threat the perpetrator posed. None of those at all are criticisms of Deputy Halverson. It's undisputed he acted heroically. But that does not mean any identification he makes is reliable beyond a reasonable doubt. Given the short exposure time, and in addition, he said regarding his experience around black individuals, he could not remember the last time he had socialized with a black person. And he had seen 5 to 6 pictures of Stanley that labeled Stanley as a perpetrator. All of that allows you to conclude it's reasonably possible his identification may have been mistaken, and based on his memory of the pictures he saw, rather than the incident itself. I will now make a few comments that apply to each of the identifications. Dr. Lampinen's expert testimony was that people can have a very vivid memory of an incident, but that vivid memory can still be mistaken. His expert testimony described how long periods of time between the incident and an identification attempt cause unreliability. That's the ski slope analogy with memory. It dips down drastically after the first initial minutes or hours. And 20 months after an incident is a long time for memory to fade. You will find the length of time between the incident and the identification in jury instruction 11. His expert testimony was that seeing pictures of a person labeled as a suspect can increase a witness's confidence that they have correctly identified that person at a future identification attempt without increasing the reliability of that identification. And his expert testimony was that it is not surprising that multiple people could all identify the same person as a perpetrator if all of those people were exposed to suggestive procedures before their identification attempt. And regarding the in-court identification attempts and their unreliability, his expert testimony was also that the research establishes and shows that defendants have been found guilty at trials where multiple eyewitnesses identified them as a perpetrator, but then they were later exonerated. Those exonerations themselves show the unreliability of in-court identifications. So it should come as no surprise to you that all 4 eyewitnesses identified Mr. Donahue as a perpetrator, and that fact does not help rule out the reasonable possibility that they were mistaken in their identifications. I will finish my remarks on the identification procedure, and again, my remarks on the other areas of evidence will be much shorter. I will finish with the lack of identification procedures the police and prosecutors used in this case. Dr. Lampinen's expert testimony, on which lead detective Sergeant Abel and Deputy Halverson seemed to agree, was that the best way to conduct an identification procedure, if your main goal is reliability, is to do an in-person or a photographic lineup. But the police and prosecutors never conducted this most reliable identification procedure, and the prosecutors have spent their entire trial intimating to you through their witnesses and through their argument today that they did not need to conduct an identification procedure because one was not necessary, given what they believed was the overwhelming evidence against Stanley Donahue. But if an identification procedure was not necessary to prove the case beyond a reasonable doubt, why did the prosecutors bother asking the witnesses at trial to make identifications if that was not necessary? Their asking of those identification questions reveals to you their belief that identification was necessary. And if they needed an identification, why would the prosecutors and the police not use the most reliable identification procedure and instead rely on the in-court identification procedure, which Dr. Lampinen said was the worst way to conduct an identification procedure if the main goal is reliability? Reasonable questions you may ask. Were they afraid their witnesses could not pick Stanley out of a fair lineup? Were they afraid they might identify someone other than Stanley from a fair lineup? It is reasonably possible to believe that the answer to both of those questions is yes. And that's why the prosecutors and the police instead chose to rely on the most unreliable identification procedure possible, the in-court identification procedure, when it was obvious to all the witnesses who the prosecutors wanted them to identify. Dr. Lampinen's expert testimony explains why that in-court identification procedure was an absolute sham. The identification procedure was unfair, unjust, and unreliable. I almost added unworthy of your consideration to that list. However, you should consider their choice to use that only identification method. You should consider why the prosecutors were willing to throw Stanley Donahue into a sea of white, then ask their eyewitnesses if they could pick the one black person out amongst the waves. You should consider why they would only use that sham procedure as a means of obtaining their desired identification. You should consider that and the lack of credibility it gives to their entire case if they are willing to present that sham procedure to you as the only method of identification. So for those reasons, there is reasonable doubt about the identifications, and that does not help rule out the reasonable possibility that Stanley Donahue might not have been the person in the cases. Moving on to the rest of the points I will discuss, and again, these will be much quicker than the identification discussion. The second point, lead detective Sergeant Abel said the person in the videos had a distinctive walk, a waddle, as he called it. So I guess we are not limited to big nose, big lips, and big forehead. You have waddle to add to that mixture. And that the waddle the person in the cases had is the same as Stanley was walking down Aldrich Road when he was arrested. But assuming Stanley does walk similarly to the perpetrator, the evidence you heard was, for example, that he and Michael Gomeyer were brothers. They share the same genetic makeup. It's reasonable to conclude that people who share the same genetic makeup, who are brothers, walk similarly to each other. So nothing about the walk, or the waddle as it's been called, helps rule out the reasonable possibility that Stanley was not the person in the cases. The third point, the height strip in the cases, which Mr. McAreevy might find for us. Lead Detective Sergeant Abel said he could conclude from that picture that the person was 6 feet tall, based on that white strip between the doors. You can judge for yourself whether that's a credible determination. But even assuming it is, a few inches in height does not help rule out the reasonable possibility that someone other than Stanley Donahue was a person in the cases. The fourth point, in remaining on the person in this early morning video that you're looking at, the testimony seemed to be undisputed that everyone thought this person in the video was the same person who came back to the cases at 10:30 or so that same day. But the prosecutors did not present any evidence that Stanley Donahue was ever found with a camouflage mask or head covering.
Objection. Your Honor, we approach.
The fifth area of evidence I will discuss is Deputy Omar's dash camera, which Mr. McAreevy might have a few screenshots for. In the dash camera, you can see for yourself, I'll get to this part in a moment, you can barely see the driver. It is difficult, if not almost impossible, to see anything in the back seat of the van. Because of that, you can't rule out the reasonable possibility that when Deputy Omar and the van crossed paths after the incident, that there was a second person in the van. And at the end of Heath Omar's dash camera, which is displayed on the screens to you now, the van drifts back for a few moments after the driver gets out and Heath Omar runs away. You cannot see anything on the passenger side of the van at this point in Deputy Omar's dash camera. Because you cannot see anything at this point, you can reasonably conclude that it would be reasonably possible, for someone to exit the driver's side of the van at this point in time without being detected on Deputy Omar's dash camera. So that allows you to reasonably conclude that it's reasonably possible someone could have exited the van at that point without being detected. The sixth point, the airbags, which I've already mentioned briefly, and Mr. McAreevy might find a few pictures of those. I mentioned this briefly. I won't dawdle on it here, remain on it here for long. Could not rule out the reasonable possibility that the airbags in the van only deploy if a passenger is there. The airbags did deploy, so you can conclude it's reasonably possible that a passenger was or might have been in the passenger seat. State's Exhibit 91 is the seventh point I will mention, and Mr. McAreevy might find that for us. That is a picture of the van as it came to rest on the Buffalo Creek Bridge. You can see how much space there is for a person to exit the passenger side of the van. Would not have at all been difficult to do so. This exhibit allows you to conclude it was reasonably possible someone could have exited the passenger side of the van after it crashed on Buffalo Creek Bridge. The eighth point, which I've already mentioned briefly, is the dog track that Deputies Steinis and Omar conducted. It's undisputed the dog picked up the driver's scent trail right where Heath Omar last saw him. It's undisputed the dog was on the trail and tracking the trail. And it's undisputed that that trail, that scent trail, never led to Stanley Donahue. The fact that the dog never led to Stanley Donahue allows for the reasonable possibility that the dog was tracking someone other than Stanley Donahue. Second point on the dog track, again, this is not necessarily a criticism, it's just a fact of the case. There was never a track attempted from the van itself by Deputy Steinis, and we heard no evidence of any other track attempts that were made from the van. Because there was never a track attempt made from the van, we do not know what that would have led to. Maybe it's reasonably possible that the track from the van, particularly the passenger side of the van, may have led to someone else. So the dog tracks, because they never led to Stanley Donahue, because they never tracked from the van itself, allows you to conclude it's reasonably possible the dog was tracking someone other than Stanley, which allows you to reasonably conclude it's reasonably possible Stanley Donahue was not the driver. The ninth point is Patrol Supervisor Deputy David Omar. And his testimony on these points on Exhibit K, the blue tab at the intersection of Highway 13 and Monticello, and the pink tab with the cows. When I say Deputy Omar now, it'll be Deputy David Omar rather than Heath Omar. Deputy Omar said it was suspicious to him that this sighting of a person crossing Highway 13 southbound, he was suspicious that that could have been the driver. If he is suspicious that that could have been the driver, that allows you to reasonably infer that it is reasonably possible it could have been the driver. And because the driver of the van, or whoever that was, could not have been reasonably able to get from this point all the way back to the point where Stanley Donahue was arrested, it is reasonably possible that the suspicions of this person crossing the road was the driver and that it was not Stanley Donahue. Supervisor Omar's testimony was basically the same thing on the cows making noise along Upper Boulder Road. He was suspicious that that could have been the driver. Given that the patrol supervisor of the patrol deputies was suspicious that those crossings, the blue tab and the pink tab on Exhibit K, could have been the driver, it's reasonably possible that the driver might not have been Stanley Donahue. The prosecutors will have a chance to rebut everything I am saying to you. And on this point of the search in this area at Highway 13 in Monticello, maybe they would come up here and argue that it was a false sighting or a false report. But certainly in this case, the prosecutors are not going to argue to you that an eyewitness might be mistaken on what they see. So if they do come up and make that argument that this was or could have been a false sighting, keep in mind how credible that argument is if they are saying eyewitnesses are always reliable. 10th, moving quicker now. There was no search for items near Highway 13 and Monticello Road the next day. For example, broken corn stalks, a travel path, matted down grass, no search for any of that. So you do not know what would have been found had police looked in that area. 11. You might wonder, what's the reasonably possible explanation as to how the person crossing Highway 13 southbound was never caught by the police? And it's reasonably possible to think that the perimeter the police set up was not as airtight as they thought it was. There is a massive police presence, all looking for the suspect or suspects for several hours, but they never found anybody. It took a KCRG news crew who first spotted what turned out to be Stanley Donahue walking down Aldrich Road. So all of those facts allow you to conclude it's reasonably possible that a person would have been able to go undetected despite the police force that was out. 12. The money supposedly found in Stanley Donahue's pockets. What are some reasonably possible explanations for that? And I will have two of them. First, there is reasonable doubt about how much of that was found on Stanley Donahue. The only evidence the only witness the prosecutors presented about that was Lieutenant Chris Smith. He did not search Stanley Donahue. He says he watched, whatever that exactly means. Deputy Steinis admitted he did not search Stanley Donahue. Sergeant Ireland, who supposedly took this bag of money, said he did not search Stanley Donahue. Lieutenant Smith said he did not even know the name of the person or persons who searched Stanley Donahue. So the prosecutors have said they showed you everything, and they promised they would show you everything. Why did they not show you the witness who actually searched Stanley Donahue and supposedly found all that money, including the security tape bills from the register alarm system that they have heavily relied on? Why would they not present the witness to you who actually supposedly found those? Without presenting that witness to you, you had no chance to weigh his or her credibility as to when, where, and how they found that. So the lack of evidence, which Instruction 6 allows you to consider when it comes to this supposed search of Stanley that supposedly led to all this money, creates reasonable doubt as to what exactly, if anything, was found on Stanley. Secondly, there were no fingerprint or DNA attempts made on any of that money. Sergeant Ireland explained that by saying he doesn't fingerprint or DNA items that come from suspects, but he does not know those items came from Stanley Donahue, if they supposedly did, because, again, he did not search, and who he got that bag from, Deputy Steinis, did not search Stanley. Secondly, the second point I will make is, I believe the prosecutor said in his closing argument that Stanley supposedly was found with more money on him than what was taken from the Casey's. You can reasonably infer from that that Stanley Donahue already had money in his pockets at the time the incident at Casey's happened. So for those reasons, there is reasonable doubt surrounding this money supposedly found on Stanley, and nothing about that claim helps rule out the reasonable possibility that Stanley Donahue was not the person in the Casey's. 13, Stanley Donahue was not wearing any shoes at the time of his arrest. That might be suspicious to you. But again, there was a pair of white Nike shoes in his van. It was his van. It was registered to him. The evidence on that is undisputed. So a reasonably possible explanation as to why Stanley Donahue was not wearing shoes at the time of his arrest is in the clamor and the uproar following the crash. He fled the van without thinking to put on his white shoes. And also the boots and the sweatshirt found near this purple mark on Exhibit K. Whoever the driver of the van was, it is reasonable to conclude that he discarded the boots because they were tough to run in and caked with mud, and he discarded the sweatshirt because he was hot. But none of those items have been tied to Stanley Donahue in this case. And that brings me to the 15th point I will make, which is there is no evidence that Stanley's DNA was found on anything outside or inside of the Casey's. That sweatshirt I just mentioned, no DNA of Stanley found on the sweatshirt. The boots I just mentioned, there was one hair found in the boot that Miss Tara Scott, the DNA person, described as dark and curly, but she could not match the DNA to Stanley Donahue, and she could not exclude the possibility that the hair belonged to someone else. So that evidence allows you to reasonably infer that it's reasonably possible those boots were not tied to Stanley. The Sig Sauer, there were two different DNA samples on the Sig Sauer, and Tara Scott could not exclude the possibility that the DNA belonged to someone other than Stanley. No DNA found on Deputy Halverson's gun, and the face mask found in the van had male DNA on it, but could it not be matched to Stanley, and could not exclude the possibility it belonged to someone other than Stanley. Additionally, there is no evidence of Stanley's DNA being anywhere in the Casey's. So the lack of DNA evidence allows you to reasonably conclude that it's reasonably possible Stanley might not have been the person in the Casey's. Regarding fingerprint evidence in the Casey's, no fingerprints in the Casey's could be matched to Stanley Donahue. There were no fingerprint attempts made to find any fingerprints on the handle of the freezer that the perpetrator put Jacob Christensen and Madeline Stepanek in. No fingerprint or DNA attempts from the black swinging door to the kitchen. That all allows you to reasonably think what might have been found in those locations had a search been conducted. Getting close to the end of this portion, the fingerprint on the Sig Sauer magazine. There are 2 points I will make on this. First, even assuming that fingerprint does belong to Stanley Donahue, the testimony is undisputed that you cannot determine how long a fingerprint has been on an item. Could have been a day, a month, a year, or any other period of time. And as Sergeant Idleland's display indicated, the magazine is a separate piece of equipment from the gun itself. So a person could handle a magazine without ever having anything to do with the gun. So even if you think that fingerprint beyond a reasonable doubt was Stanley's, it does not add much to the case. Secondly, there is reasonable doubt that the fingerprint was Stanley's. The match was made by an uncertified fingerprint examiner with a very faint partial print, only 20% of that print, and with 17 points of ridge detail, when he testified that a full fingerprint could have over 100 areas of ridge detail. So 20% of a print with 17 out of at least a possible 100 ridge details, that is reasonable doubt about the identification of the fingerprint. Secondly, there was a second print on the magazine, and Investigator Kruger could not rule out the possibility that that print came from someone other than Stanley. So the fingerprint on the magazine, or the prints on the magazine, does not, still allows you to reasonably conclude it's reasonably possible the person in the Casey's might not have been Stanley. Two final points on the evidence. These will be quick. The difference in behavior between the perpetrator in the Casey's and Stanley at the time of his arrest. Mr. McAreevy might have some screenshots for Mr. Donahue at the time of his arrest. He was completely cooperative and completely cooperative with the DNA evidence. If you can contrast that with the behavior of the person in the Casey's, those you can reasonably conclude are two different individuals based off the behavior. Finally, the last piece of evidence I will discuss, who, if not Stanley, is a reasonably possible explanation as who might have been in the Casey's. And I would suggest as a reasonable possibility, Michael Goldmeyer, born in 1997. He has a connection to Stanley, as we all heard, based off them being brothers. He therefore would also have a sister in Ryan, Iowa. He had identification cards, albeit old ones, that were in the van. There are at least two different pieces of paperwork in the van. The investigators, lead detective Sergeant Abel, said from the witness stand that he did not look into Michael Goldmeyer until about 2 weeks ago, which was essentially when our trial started. If there is investigation still ongoing at the time a trial starts, that is an indication to you that there is reasonable doubt. If a case is ready to be proved beyond a reasonable doubt, you don't need to be investigating anything. No attempts were made to contact Michael Goldmeyer. No attempts were made to go to Chicago despite having his address. And as a general matter, you can reasonably conclude he fits the description of the perpetrator that the eyewitnesses in this case made, or gave, I should say. So for those reasons, you can conclude that it is reasonably possible that Stanley Donahue was only ever a passenger in the van that evening, and you can reasonably conclude that it's reasonably possible he might not have been the person in the Casey's. So for that reason, I ask you to return not guilty verdicts on all 10 counts. The second part of this portion of the argument, which will be just a few minutes here, I know I've been going on for a while, is if you do conclude beyond a reasonable doubt that Stanley Donahue was the person in the Casey's, what are the crimes that you should issue guilty verdicts for? We are in no way conceding that's been proven beyond a reasonable doubt, but for the sake of argument, I will assume that at this point. And if you conclude that, I will say right now that the guilty verdicts should be returned on counts 2, 4, 5, 7, 8, 9, and 10. So I will only discuss counts 1, 3, and 6. Count 1 is the attempted murder charge. To have reasonable doubt, all you have to do is think it's reasonably possible that the perpetrator might not have intended to kill Deputy Halverson. On this point, I must talk bluntly for a few moments. And the best evidence that the perpetrator might not have intended to kill Deputy Halverson is Deputy Halverson himself and the fact that he is alive. The perpetrator had every opportunity to kill Deputy Halverson if that was his intention. The perpetrator did not do so. That is reasonable doubt about what the perpetrator was intending to do regarding Deputy Halverson. It's undisputed he had Deputy Halverson's fully loaded gun, 16 bullets, 15 in the magazine, 1 in the chamber. It's undisputed the gun did not have a safety. All you had to do to shoot it was pull the trigger. Deputy Halverson told the perpetrator twice, "Please don't kill me, please don't kill me," and the perpetrator did not kill him. The entire encounter happened in about 3 seconds. That's a very short amount of time. It's reasonably possible to think a person could not form any specific intent within that 3-second time frame. The shots that were fired were all in the bulletproof vest or lower. You can use your common knowledge that people understand that police officers wear bulletproof vests. No shots to the head area, even when Deputy Halverson, through absolutely no fault of his own, was helpless on the floor, and a shot there could have been fired. Finally, in looking at the entirety of the incident, the loaded gun was left in the van. If the perpetrator had an intent to kill, why would you leave the loaded gun in the van rather than take it with you and keep shooting? And there was no intention or purpose on the perpetrator's part, as the evidence allows you to reasonably conclude, that he was trying to eliminate witnesses in any way. If that was his intention, what's the explanation for Jacob Christensen and Madeline Stepanek? So for those reasons, there is reasonable doubt on elements 2 and 3 of the attempted murder instruction that requires you to return a not guilty verdict on that count, and instead on that count find the perpetrator, if you conclude that beyond a reasonable doubt that it was Stanley Donahue, of assault causing or with intent to cause serious injury. Count 3, the robbery charge against Madeline Stepanek. That is in instruction number 26, on page 26. And there is not proof beyond a reasonable doubt of the second element in that instruction. It's undisputed that the perpetrator never displayed the weapon in Madeline Stepanek's presence. And it's undisputed, or at least Madeline Stepanek only testified that the perpetrator said, "Is there money in the kitchen?" and "Get in the cooler." There is not proof beyond a reasonable doubt of any purpose of putting Madeline Stepanek in fear of an immediate serious injury. So for those reasons, the verdict, regardless of the identity on count 3, should be not guilty. Now, I will briefly mention count 6, which is on page 34, instruction number 34. And that is the trafficking and stolen weapons charge. Element 2, there is not proof beyond a reasonable doubt. Deputy Halverson's firearm was not stolen when the perpetrator went to take possession of it. So the perpetrator was not taking possession of a stolen item or a stolen firearm. He was simply taking possession of a firearm. Wanting to steal a firearm is different than taking possession of a firearm that has already been stolen. So regardless of the identity issue, your verdict on count 6 should be not guilty. Concluding my argument now, ladies and gentlemen, with the comment on some of the prosecutor's comments, in particular, their comment that they would show you everything. They said that in their opening statement, and they said that in their closing argument. But those statements did not turn out to be true. As I previously stated, they did not show you the witness who supposedly found the money on Stanley Donahue. They did not present Stanley Donahue's sister and Ryan as a witness. They did not present any of the Goldmeyers or anyone else associated with the van as witnesses. They did not present the Marion police officer who took the report of the sighting near Highway 13 and Monticello Road. They couldn't even say the name of that officer, and they couldn't even say the name of the person who made the report to the officer. And they could not show you anything about that out-of-court, one-man photo show-up that Jacob Christensen supposedly was a part of on June 21st. Additionally, as the evidence is shown in this case, the investigation was ongoing at the time of the trial. Lead Detective Sergeant Abel was still looking into the Goldmeyers and Gilbert Reynolds at the time of the trial, and Deputy Matt Altman was looking into the airbag issue between the two times he testified. So the prosecutors have not shown you everything that they could have, and they have shown you that they and the police were still investigating this case as the trial was happening. That should give you reasonable doubt. And I will conclude with that short story and the quote that I think is applicable to you. And I beg your indulgence for just about 5 more minutes. And it will take me just a moment to set up the quote. But that story begins on July 2nd of 1863, nearly 160 years ago, in a small college town in Pennsylvania called Gettysburg. It's the second day of 3 days of the Battle of Gettysburg. And both armies realize that there is an important spot on the battlefield that will control the battle. You control this spot, which was a hill called Little Round Top, you win the battle. So they had begun a literal life and death race to control that Little Round Top. And a regiment called the 20th Maine Regiment was ordered to hold that hill, and they were on the very end of the line. And that is where my story picks up, or the quote is set up to. That 20th Maine Regiment was ordered to hold its position at all costs. And writing years later, a Maine citizen said of those orders, "Stand firm, ye boys from Maine, for not once in a century are men permitted to bear such responsibility for freedom and justice, for God and humanity, as are now placed upon you." So I say to you, as members of the jury, stand firm against the prosecutor's attempts to convince you that the verdict in this case is obvious. Stand firm against the use of racial caricatures and stereotypes of big noses and big lips. Stand firm against any pressure you may feel to reach a verdict just because you have seen evidence of terrible and horrendous crimes. Reaching a verdict for the sake of reaching a verdict is not justice if there is not proof beyond a reasonable doubt that the verdict is reached against the correct person. For not once more in your life will you likely be permitted to bear such responsibility for freedom and justice and humanity as you are required to bear as a part of your presence on this jury. That great and life-altering responsibility is one you will bear with the utmost care, concern, and courage by giving honor and weight and meaning to the fundamental and cherished ideals such as the presumption of innocence, proof beyond a reasonable doubt, and the idea that a person can get a fair shake at a fair trial regardless of what they may look like. And it took the 20th Maine nearly all it would cost, but they held their position on Little Round Top, and they won the battle. And to give that battle meaning, perhaps our greatest statesman, and perhaps our greatest speech, gave that victory meaning when President Lincoln delivered his Gettysburg Address in November of 1863. There's a copy of it in the courthouse at the bottom of the staircase to the main level if you look off to your right as you get down there. And in that speech, President Lincoln spoke of a nation conceived in liberty and dedicated to the proposition that all men are created equal. And he spoke of the war giving a new birth of freedom to that obvious part of American society who shared the same skin color as Stanley Donahue. Continuing to implement those ideals, in this case, that President Lincoln discussed, means that however long your deliberations may take, that you ensure the ideas of the presumption of innocence and proof beyond a reasonable doubt are not merely words on pieces of paper that can be discarded whenever the state wants to obtain a guilty verdict, but they are words that actually have meaning to people in the position that Stanley Donahue is in front of you this afternoon. So honoring that presumption of innocence and holding the prosecutors to the burden of proof, I will conclude with asking you, first, because of reasonable doubt on the identity, not guilty verdicts on all 10 crimes, and if you do find beyond a reasonable doubt that Stanley Donahue was the person in the case seized, only guilty on count 1 of assault with intent to cause serious injury, not guilty on count 3, the robbery allegation regarding Madeline Stepanek, and not guilty on count 6. The prosecutor gets a second shot to speak with you. I will not have a chance to respond, so please think what my responses would be when he is discussing his rebuttal with you. And please, if I have not mentioned something that you think I should have, discuss it fully and fairly in your jury deliberations. And it has been my pleasure to appear before you, and it has been my pleasure to represent Stanley Lavelle Donahue.
Thank you, Mr. Stiefel. Ladies and gentlemen.